Good morning. The time being 10:03 on the 24th. I would like to bring this subcommittee to order. I've been around here for a number of years, and the task that this subcommittee is facing is incredibly difficult, and I'm not really sure there is a workable answer. These bills don't belong here. They belong a few hundred miles south of here in Washington, because this is a problem that is a national problem affecting every state. It is not only affecting New Hampshire, and only because the U.S. Congress has not been willing to step up to the plate. We in this state are doing what has happened in a number of other states, and we're trying to do the best that we can. A number of us have worked on this, listening to people in the public, listening to information that we received, and I can tell you definitely that the people who worked on the amendments that you now see before you, no one is completely happy. And therefore, I think we might have done a pretty decent job. What we tried to do is pay attention to what was happening in other states, be as close as we possibly could to that, to make it a little easier when the time comes for the U.S. Congress to decide what to do. But we had to honor some differences which make sense in a small state. You have before you, that I've distributed here in the room, a draft amendment dated the 22nd of the month. And I must say that I violated one of my basic rules. I wrote that it was a draft. I put the date, but I did not put any names on there. So I'm sorry about that. But these are proposed amendments that the chairman of the full committee, Chairman Lynn, and the chair of the subcommittee, me, would like to jointly introduce to the full committee if in fact the subcommittee agrees. I also want to add, because all of this is a moving target, there are some additional changes that Chairman Lynn is going to bring to our attention that aren't in these amendments. But at least you can begin with some written copy that might keep everybody on the same page. And I am indebted to all of you who have let us know what you consider important or what changes you would make, and also to Representative Erf, one of the co-sponsors of the bill, and to former Representative Kirk for using a lot of their time to help us get as close to yes as we could get. So with that, I would like to present to you these two amendments that are headed draft amendment with the date of 10/22, and they're both separate and nonetheless relate to each other, and which is why each of the bills was sent here. So with that introduction, I think the next thing I would do to share the wealth here is to ask Chairman Lynn if he would begin with the House Bill 314, and then do that first, and then we can go on to the Senate bill. And Chairman Lynn, if you would, perhaps you could highlight some of the key differences.
Yes, absolutely. Oh, thank you. So, I guess the first thing I would say, I'll go over the House Bill 314, the proposed changes first. The thing I would say at the outset, though, is one of the things that we were concerned about, because these two bills do have some overlap, as I think everybody's aware, and we wanted to make sure that we we were we weren't having anybody subject to both bills. We weren't, in other words, somebody that's going to be regulated. We didn't want to have them kind of subject to both bills. So the only thing I would say, I'll talk about 255 later, but the one thing that I would say is the the entities that I'm going to talk about now that will be covered by 314, House Bill 314, are by language that's been added to 255, which I'll talk about later, are specifically excluded from 255. So that's and it's a pretty substantial, a pretty significant exclusion, which I'll talk about. But anyway, so let me turn to 314. As you may recall, by way of background, the original bill purported to establish an expectation of privacy that applied to certain information, and then it then went on to say that that governmental entities can only obtain private information from what are referred to as third-party providers in certain ways. And then there was a provision that purported to that at least arguably would have allowed private causes of action against both the government and private entities, and that was the subject of some concern. I had proposed an amendment that changed that, but what we came up with in the amendment to 314 that you have before you is a proposal that that basically applies only to the covered entities. And let me talk about initially what the covered entities are, because I think this is particularly important. You'll see in what has been designated as proposed RSA 507I, in Roman numeral 2, it describes what the covered entities are. And it refers to them as third-party providers of information and services, and it basically goes on to say that it means the following: the people who provide, or individuals who provide, the following kinds of services: cellular and landline telephone, electric, water, or other utilities, internet service providers, cable television, streaming services, social media services, email service providers, banks and financial institutions, insurance companies, and credit card companies. Now that's a pretty good list of entities, but it's nowhere near as large as the entities that would be covered by 255. Then in section I1, Roman numeral 4, there is a definition of what available to the public means, because information, as I go through this, you'll see information that is made available to the public, that is available to the public, is basically excluded from this. In other words, if information is available to the public in accordance with the definition here, then it's not considered to be personal information. So subsection, then we go on to subsection I2 of the bill. That is really the heart of the bill. And essentially it says, I'll just read it. An individual shall have a reasonable expectation of privacy in personal information, as that's defined in the definition section, including content and usage given to or held by a third-party provider of information and services and not available to the public. Third-party providers of information and services shall not disclose personal information of an individual to anyone unless one of three conditions exist. First, such individual has given explicit consent for the disclosure to one or more of the information to one or more others. Secondly, an emergency exists where there is a danger, an imminent danger of death or serious serious physical injury to an individual, or substantial loss or destruction of property if the information is not disclosed. Or third, the information is disclosed in accordance with the provisions of sections I3, which I'll get to in a moment. In section I2, Roman numeral 2, we've set out what specific requirements of what needs to be met for consent. And it provides that, as you'll see, that it is an opt-in requirement of consent. Now that's different. Notice that that's different from what is in 255, which again we'll talk about after, but this is an opt-in consent provision, and it requires that if a provider of information is going to request consent from an individual, the request for consent has to be communicated in a simple, clear, and unambiguous form, and must state the purpose for which the consent is sought. The consent communication has to be separate. This is I think a big point. The consent communication has to be separate from any other communication that the provider sends. So it can't be, where 35 pages of gobbledygook and one of them says, I can, by responding to this, I consent. It can't be that. And then the last thing, and this is, I think, probably the heart of it, the communication must be structured so that the individual is required to respond by performing an affirmative act to opt in to consent. So you have to opt in. So then I want to make sure that I've got the right.
Your last minute change is on
Is on that. Okay, it's on this file. Okay. All right. So I'm going to talk about. I'm going to talk about
this.
Yeah.
And then say, and.
Okay. All right. Yeah. No, that's a good point. So this is 255. This is. Okay. So then. All right, so then in I3, let me turn then to section I3, which provides, this is the one, this amendment is different from earlier versions of the bill in that I3, it now describes when a covered provider can give information to, when the request for the information comes from a government entity. But bear in mind, this is different than the earlier versions, which were aimed at the government entity. In other words, the way the earlier version was drafted is it said the government entity can only get information in certain circumstances. This is changed so it doesn't apply to the government entity. It applies to the private provider. But what it says is, if you're a private provider that's covered by the act and the person that's requesting information from you is a government entity, you can only give it to the government entity if it meets the requirements of Section 3. So the first one is when requested to do so by a government investigative, regulatory, administrative, or adjudicative body, acting within its authority. The second is when required to do so by a subpoena duly issued by a government regulatory body or uh, or administrative body acting within the scope of its authority, or by a duly impaneled grand jury or by a court. The third one is when compelled to do so pursuant to a duly issued search warrant or pursuant to a judicially recognized exception to the warrant requirement. The fourth subsection 3, I3,
D.
Roman numeral 1D, when requested by the Division of Emergency Services and Communication for purposes of responding to or assisting with emergency 911 telecommunications, and then E, in an emergency where there's immediate danger of death or serious physical injury to an individual or substantial loss or destruction of property, requires the disclosure without delay of personal information concerning a specific individual, a telephone number, username, or other unique identifier, and where judicial process cannot be obtained in time to prevent the identified danger. The subsection 2 of I3 provides that a third-party provider of information and services who discloses personal information to a government entity pursuant to one of the five situations that I just described shall contemporarily provide notice that it has done so to the individual to whom the information pertains, unless first the government entity seeking the information demands that such notice not be provided and furnishes to the provider gives the provider the basis of the governmental entity's authority to make such a demand, or second, a court has issued an order that such notice not be given. So in other words, the default position is if you're a provider and the government says, give me certain information, and assuming that that it's within one of the five provisions that allows the government to get the information, the provider can comply. The provider must comply, but the provider has to give notice to the individual that it pertains. In other words, Mr. Smith, you should know that the government has asked for certain information to be turned over to you, to them, relating to you, and so we've done that. That has to be done contemporaneously unless one of the situations is that is described in that section would prohibit it. So, for example, if it were a grand jury request, the prosecutor presumably would say, or may say, don't disclose this information because it's covered by grand jury secrecy. If that applied, and grand jury secrecy wouldn't necessarily apply in all circumstances, but it might very well apply. Importantly, subsection I4 of this provides that no third-party provider of information and services may require a waiver from the provisions of this chapter as a condition for any individual to do business with it. So it's got to be, it's got to be a real waiver, not that unless you waive this, we're not doing business with you. And then Section 5 is the remedies section. And one of the big things, as many of you may know, one of the big things for me was my concern with both 255 and 314 was the prospect of a private right of action. You'll see in I5 that we have eliminated the private right of action. The Attorney General is allowed to enforce the statute and to invoke the provisions of the Consumer Protection Act, which provide for, in the case of the in the case of actions brought by the Attorney General, the Attorney General may seek civil penalties or actual or up to $1,000 in actual, I'm sorry, actual damages or penalties up to $1,000 for each violation of the chapter. So that's 314, and I should say I was going to talk about the changes that the ones that are in here.
Yeah.
Yeah. So you know what, the proposed amendment that was distributed. I'm sorry, sure.
Okay, just stop for a minute. As I said at the beginning, nobody's completely happy, which is why I think these might be good. The private right of action has always been something that I thought made a lot of sense because we are talking about the individuals who choose to live in this state and should have the rights guaranteed to them under the state constitution. However, in trying to do the best that we possibly could do in a world with disparate views, we let that go. In what we're proposing to this subcommittee. Now, in addition, because Chairman Lynn has in fact now is approaching his fourth year, end of his second term in the legislature, he still, by and large, keeps close to his heart and his brain his responsibilities that were developed when he served in another branch of government. And because of that, he read this and then said, okay, but if we're talking about the Consumer Protection Act, where do we say that? And the question was a legitimate question. So after these drafts were prepared, then Chairman Lynn wants to present to us some additional changes. And so those don't appear in the draft that you have seen. They do appear in another draft that there might not be any need to distribute to you, but which the chairman's going to explain now. I think that's the right background.
So that the subsequent draft that Representative Smith just referred to, what it changes from the one I just went over, is, I just want to make sure I'm right on this. A, B, C, D, and yeah. A, B, C, D. Yes. So what it changes is, if you go to the one I just went over, and you go to section 507I 3 Roman numeral 2. So that's where the changes start on the one I'm about to talk about now. So what I was thinking when I finished the drafting of the one we just talked about, I really sort of said, well, wait a minute, don't we, that as I just explained, said you have to provide the provider who gets a request from the government to provide information has to give contemporaneous notice. And as I was thinking about that, about 4:00 in the morning one morning over the weekend, as I was obsessing about these amendments, it seemed to me that what I had forgotten is, what I thought about was, well, wait a minute, why should it be only contemporaneously, particularly if you're talking about a request in the form either of a request from a government entity or of a subpoena from a government entity? Why shouldn't the government entity be required not to demand production of the information for a reasonable time, so that if the individual who is the subject of that request thinks that he or she has a basis to object, the individual has time to go to court to make the objection? So in subsection, in the new amendment, that I'm going to talk about now, in subsection I3, Roman numeral 2, it says, when a government entity seeks the disclosure of information from a provider of information and services, pursuant to sections 3, 1A or B, and that's 1A is the request, and 1B is when it's made by a subpoena. The request or demand for such information shall not require production of the information sooner than 10 days from the date the request or demand is made. That is a change in that that is now a restriction on the government. It says to a government agency or even a grand jury or whatever, it says to whoever from the government is asking for information, if you issue a subpoena, for example, you can't demand production in less than 10 days. And then it goes on to say, within 5 days of receiving such request or demand, the provider shall notify the individual to whom the information pertains that the request or demand has been made, so that such individual has an opportunity to pursue judicial remedies to prevent compliance with the request or demand if there are valid grounds to do so. However, there's then a proviso. Provided, however, that no such notice shall be given if, in the first instance, the government entity seeking the information demands that such notice not be provided and furnishes the provider with the basis of its authority to make such demand, or 2, a court has issued an order that such notice not be given. So that if there are legitimate reasons, for example, a grand jury subpoena, that might be one, under certain circumstances, for the government to say, no, we want no Bank of America, we're issuing you this subpoena, but we don't want you to disclose to Bob Lynn, the person whose records they're asking for, that the grand jury has made that request. They can say, we have the authority to do that, and the bank is required not to give me notice. Or if a court has issued an order saying don't give any notice. So then Roman numeral 3 of that section deals with the other three circumstances in which the government may request information. And that's in the case of a search warrant or an emergency. And so what it says in those circumstances, if it's a search warrant or if it's one of the emergency situations, then in that circumstance, the provider has to give contemporaneous notice, not advance notice, but contemporaneous notice that the search warrant has been executed, or that or that they're giving over the information pursuant to an emergency. And again, that section has the proviso that if the government entity has the authority to demand that the search warrant not be disclosed, or if a court has issued an order requiring that the search warrant not be disclosed, or that the emergency not be disclosed. It's kind of probably would be difficult to imagine an emergency, but maybe that could happen. Anyway, in those circumstances, then no disclosure is made. So I guess what I'm saying is I think the latest amendment is just a little more complete. It sort of deals with what happens when one of these requests by the government is made. What are the constraints on the government in making the request, and what does the provider who gets the request have to do vis-a-vis the individual that's the subject of the request?
Now you can take a deep breath. Could I have that file?
Yes, of course.
Members of the committee, what I'm going to pass out now, with just a slight, what I'm going to pass out now is the amendment as further explained by Chairman Lynn. I am crossing off in this very official way, the cover page, because the cover page makes it seem as if this is the bill that had been presented to us with all the numbers on it, and I don't want people to be confused. But if you could, so, and this will now, can now go to the public. So the first page is just crossed off with all the numbers and codes and whatever, but the rest is here. And if somebody could just come, okay, let me know if that's not enough.
Yeah.
Okay, thank you, Representative Kirk. So this amendment then includes all of the changes that were in the first one we presented to you, plus the additional one dealing with consumers. And now I would like to ask the committee members if they have any comments or questions, or if they would like to hear from anyone else on these changes. Representative Andrews.
There we go. Thank you, Madam Chair. Yeah, my only thing on these amendments is I believe no matter what our opinion is here and now, they should be both taken to the full committee because it just should be voted on by everyone.
Oh, of course, the process, as always, is that the subcommittee would make a recommendation to the full committee on November, and if we can do that today, then we as a subcommittee will not be meeting again. If we can't do that, we would meet again as a subcommittee. We have to prepare a recommendation to the full committee. On November 8th, the Chairman Lynn has called for the full committee to come together for a work session, and where it is appropriate for an executive session to vote on all of the retained bills. And if we can get through that process on the 8th, so be it. If, for example, the full committee suggests other amendments or other changes that would have to be considered, those would be prepared, and then we would come together again on the 15th to take our final votes on all the bills that had been retained by this committee. Those bills would then go to the full House, and they would be voted on the 3rd, or the 4th, or if it goes on forever and ever, on the 11th. And so you're absolutely right. And fortunately, New Hampshire being, I believe, the only state in the United States that does this, no bill ends up without having been voted on by the full committee and by the full House. So are you okay with that, Representative Andrews? Okay. Meanwhile, this doesn't have to be cast in stone yet. And the sun's in my eyes, but I can imagine. I know who would like to ask a question. Representative Turner.
Am I getting a reputation? Just a specific thanks for sharing this language, because I was trying to put the pieces together of what you were saying, which sounded very reasonable. So am I reading that this is there's a 10-day waiting period before you give it out, but 5 days after the demand is made, before within that period you have to give the notice to the person who's the recipient. So is it the intent that there be 10 days for that person to to object, or because it seems like in this instance maybe they only get the 5 days? Am I
No,
reading
that's
that
right.
right?
My intent was to give only 5 days because I think that this is my intent was this is some, particularly if it's, if it's if it's a request for a government agency, I can, just from my own prior experience, there can often be the government's in a hurry, and often for good reason the government's in a hurry, and so I guess I thought that 10 days to comply, in other words, 10 days to demand compliance was probably, you shouldn't go beyond that. And therefore, in order to give the person at least 5 days to object, that's why that's why it's worded the way it is, so that the let's say let's say this is a subpoena to a bank. So the bank gets a subpoena. It says provide the information on Lynn's bank records, and it has to say if today is the 24th, it can't do it for 10 days. But now I'm the bank. I've got to give within 5 days. I've got to give notice to Lynn that by the way, we've got a subpoena saying to turn over your records, and we're going to do it on day 10, unless somebody tells us not. Basically, unless somebody tells us not to. And then what I can do is, I can go and get my lawyer and say, wait a minute, they subpoenaed me. There's no basis for this. I want you to move to quash the subpoena, and my lawyer, presumably, or me, would have 5 days to do that.
Yeah, thanks. That's how I read it. I just wasn't sure if that was what I was correct in, whether that was the intent. So thank you very
That
much.
is the intent. Yes.
Any other questions from us? Would the members of the subcommittee be interested in hearing any reactions from others in the room, or would you prefer at this point to focus within the subcommittee on our discussions? Let me reword that. Does anyone have any objection if there is someone in the room who would like to add a comment or ask a question? All right. Is there anyone in the room who would like to add a comment or ask a question? And I begin by reminding you that we do not live in a perfect world, and no one is claiming that this is perfect. And so I want you to keep that in mind. Go ahead. I know I should remember your name, but I've just forgotten it. I'm sorry.
I'm Matt Schwartz from Consumer Reports.
Thank you.
So, I'll caveat all of this that I just saw these amendments this morning, so I might be misconstruing things, but I have some initial thoughts. On 255, I think that since the last time we've met, the exemptions kind of make it.
Wait a minute.
We're
We've only presented HB 314 right now.
Right.
So we haven't done anything with 255. We'll get to that once we finish 314.
Sure.
Because they are two separate bills, although
Yeah.
related to each other. And for those of you who might have been late and not heard the introduction, if you are covered in one of these bills, you are not covered in the other, in order to make clear the differences in how we were pursuing this. So now that you know, we're focusing first on the House bill. Do you have any comments on the House bill? And if so, great. And if not, you can come back when we get to the Senate bill.
Yeah, okay. It might be better to talk about them together when we discuss them both, because they're very intermingled in how they deal with things. So I'll let you talk about 255. I have thoughts on 314, but they make more sense in light of what happened with 255.
Okay, so you'll do that when we get to the Senate bill.
Yeah, I'll wait.
Okay, anyone else now? Yeah, have you had a chance to look at the proposed amendment? I don't want to shut off any debate. you know, we're trying to do the best that we can. So if anybody has anything, please let us know. All right. I don't see anyone else. What about anyone else on the committee? Do you have any questions about what we've attempted to do here with these two bills, and in order to try to actually play the role of Solomon without a baby being present, and thank goodness, but trying to again reinforce that this doesn't belong here at all. It belongs in Congress, but we are going to fulfill our obligation to the citizens of the state by doing this. Anything else?
No, I guess, I just want to, I would make a comment. I really want to, I mean, given where we started out on these bills and the really wide disparity of views, I just want to express my thanks to the chair and to Representative Kirk, former Representative Kirk, and Representative Erf. I really think that this was a significant compromise all around, people coming together, and I think, at the risk of sort of my tooting the horn of the four of us, I think we did a pretty fair job of compromising and coming to a point where at least the four of us can agree. Now, the rest of this subcommittee, you may have different views, and maybe the whole committee will think we're all wet, but I hope they don't. And so I feel like I'm happy at the progress we've made, and I thank you, Madam Chair.
And I thank you. Because they are separate bills, unless you have an objection at this point, I would like to ask the subcommittee for its recommendation to the full committee on the House Bill 314. Do you feel at this point ready to make a recommendation to the full committee that will review this on the 8th of November? So if one of you would like to make a motion, I would be so inclined to accept that.
So is it appropriate for me to make the motion, or should somebody else?
Well, I think Representative Turner might be willing to.
Yeah, I'd like to make the motion to accept, I guess, the amendment as distributed, the revised amendment as distributed in the last draft.
Okay, and is there a second? Okay, so moved by Turer and seconded by Andrus. Is there any further discussion? If not, I think we could probably just do this by a show of hands rather than a roll call. So if you are in favor of the motion to present the version with the scratched off first page, could you just raise your hand? Okay, so that is unanimous. So 314 will go on to the full committee, and what will be before us that day is a newly drafted version of this with the proper headlines. Okay, now let's go from here to the Senate bill. And so I would like to open up discussion on Senate Bill 255, where we are acknowledging, I think very, very significantly, the differences between the two bills and who they apply to. understanding that we hope in each case we are honoring the rights to privacy of the citizens of the state in the way that is most realistic, if not the most ideal. So let's see. Representative Lynn, why would you like to, this is a different kettle of fish or bowl of wax or something, would you like to present the Senate, the changes that we're proposing in the Senate bill?
Yes, thank you, Madam Chair. So let me go through it, sort of line by line, if you will. With the changes are reflected in bold. So I think the first change that you will see is in section 5. I want to make sure I'm right on that I haven't missed something. Yes, in section 507H2, you'll see that we've changed the threshold applicability.
That would be on page 4, line 23 of the draft amendment that you have before, well, it's actually line 24 of the draft amendment that you have before you.
And so it says that during that this bill is applicable to persons that conduct business in this state or persons that produce products or services that are targeted to residents of this state, that during a 1-year period, controlled or processed the personal data of not less than 35,000. It's reduced from 100,000 to 35,000 unique consumers. And we've added the word unique because what we want to, that is designed to prevent, it's designed to make it clear that if I'm the consumer of some business and I'm the one that deals with the business 35,000 times in a year, that doesn't mean that the business qualifies. It's got to be 35,000 different individuals that in order to qualify. And so it's reduced from 100,000 to 35,000, and then as the second trigger, it would be or controlled or processed the personal data of not less than 10,000 unique consumers, and derive not more than 25% of gross revenue from the sale of personal data. So that's a significant change. Then you will see the next change, and this is the change that accomplishes what I talked about before. That is removing from this bill the entities that are covered by 314. So it adds an exclusion in RSA 507H3. It adds a new section, Roman numeral 1G.
And that's on page 5, line 4 of the draft that you have in front of you.
And that's for and you'll see that this definition is virtually the same, almost word for word, as in as the definition in 314. Individuals, organizations, or legal entities which collect personal information about an individual in connection with providing the following kinds of services: cellular and landline telephone, electric, water, or other utilities, internet service providers, cable television, streaming services, social media services, email service providers, banks and financial institutions, insurance companies, and credit card companies. So those people are excluded from 255 because they are covered by 314. The next change is in
Page 6, line 21.
right. And this is you'll see that in this section, H3 Roman numeral 2, there are listed a bunch of organizations that are not covered, or types of information that are not covered. And what we've done is, in response to a request by someone who represents someone that provides that sells chemicals that could be precursors for controlled substances. They asked that we add an exemption because they are required by federal law to provide certain information. So that Q, and the new proposed subsection Q of that says, personal information maintained or used for purposes of compliance with the regulation of listed chemicals under the Federal Controlled Substances Act. So that's, I mean, that, it seems like that made perfect sense to add that. The next change is in subsection H4, and it's in Roman numeral 2. You may recall that in the original bill there is a requirement that the controller of information have establish a procedure for exemptions, for a procedure for somebody to say, I don't want my personal information given out. Under the original bill, that was established by the controller of the information. We've changed this to say it's the Secretary of State that will describe this procedure. And as you'll see in other sections that I'm going to get to, the idea of this is so that the Secretary of State will establish one procedure for people to be able to opt out. In this bill, it is an opt out rather than an opt in provision, but this says the Secretary of State will establish one procedure that all covered companies are to comply with. So we changed that what would have been allowed under the original 255 that basically said, look, company A can have this procedure for opt-out, company B can have this, company C can have this. We basically said the Secretary of State will establish a procedure that all companies that are subject to this must comply with. And that seemed to me, again, this is one of the areas of compromise. In a perfect world, I might have said, nah, maybe something else, but I understand the argument on the other side, and I think this makes perfect sense in that spirit.
If I could interrupt at this point for just a moment, you will see as you continue to read this section that the word controller appears, and it should. You do not think that should be taken out and substituted with Secretary of State. It is the controller who's going to have to apply this, but the standard will have been established by the Secretary of State.
Very, very good point. That's exactly right. And you'll see then that the reference to the Secretary of State also appears in RSA 507H Roman numeral 6. I'm sorry, H:6 in Roman numeral 3. Which reads, a controller shall provide consumers with a reasonably accessible, clear, and meaningful privacy notice meeting standards established by the Secretary of State. And then it goes on for further requirements. And then in subsection, that same subsection, Roman numeral 5A, says a controller shall establish and shall describe in a privacy notice consistent with the requirements of the Secretary of State, one or more secure and reliable means for consumers to submit a request to exercise their consumer rights. All right. Next. Haven't missed anything.
Page 16.
Line 20.
Yeah, okay, so, right, so, so this, now we get to the enforcement section. And you may recall in the original bill, there was a requirement, that the, that the Attorney General give, someone who was, a covered entity that was alleged to have violated the bill, the Attorney General was required to give that entity the option to cure, which was a subject of some debate in the committee. So what this does is to change that, and actually I had proposed an earlier amendment that was we had discussed, but it hadn't come up for a vote. But it basically says that during the first year after this bill takes effect as law, during that first year, yes, the Attorney General must give the entity that is alleged to have violated the statute an opportunity to cure. But after that first year, it's the Attorney General does not have to give it, but has the option to give it. So that's kind of consistent with that earlier amendment that I had talked about. And it in subsection 3 of H11, the original version is changed so that it says, in the circumstances, that is after January 1st of 2026, after the bill's been in effect for a year, it then describes when the Attorney General is going to exercise, has the discretion to allow cure. It describes the factors that the Attorney General should consider in deciding whether to allow an opportunity for cure. And then the last change, and this is in subsection Roman numeral 4 of section H11. It says, nothing in this chapter shall be construed as providing the basis for or be subject to a private right of action for violations under this chapter, and the words or any other law has been added, which is what a number of the other states, I believe Connecticut and the other states also have added this. And the purpose of that is just to ensure that we don't, clever lawyers don't say, well, yes, we can't, there's no private right of action under this, but we're bringing our action under the Consumer Protection Act, or we're bringing our action under something else, and therefore it's okay. This is designed to capture that. Basically make it clear there's no private right of action, period, full stop. So that's really it. And as I say, I think the most significant change is the change that cuts out from this bill the entities that are covered by 314. That's and I think we'd have to concede that that's a pretty significant number of people of entities are cut out. But it's the kind of entities that it seems to me there's a particular interest in preserving, in protecting the privacy of information that those entities hold about individuals, and therefore they should be subject to the more onerous requirements of 314, and in particular the requirement of an opt-in for that kind of information as opposed to an opt-out. So with that, I'll shut up.
Thank you, so that you can see that this is the much longer bill, but the changes are probably a little more easy to understand. Anybody on the committee have any questions, comments that they want to make at this point? Is there anyone in the audience who would like to make constructive comments to help us find our way? Yes, Mr. Schwartz, this time I remember.
Thank you again for allowing me to speak. Matt Schwartz
course.
from Consumer Reports for the record. And thank you for your continued work on this legislation. And we appreciate that a lot of these discussions are being held in public with the opportunity to comment, and that doesn't go unnoticed, and it's appreciated. So again, I'll start with the caveat that I've just seen the amendments that we're talking about this morning, and so I could be totally misinterpreting things. But I think the simplest way to sum up my thoughts about both of them, both of these bills that we were talking about, is that they do pretty different things, and I don't think that they are necessarily have appropriate substitutes for each other. We came into these discussions on SB 255 thinking that we wanted some, narrow but substantial tweaks that could make that bill kind of more actionable and workable for consumers. One of those things was lowering the threshold so that the bill would actually cover businesses in New Hampshire that had collected substantial amounts of information about consumers. And we're happy to see that that amendment was included. But I think in section 507H2, the new exemptions kind of, we talked about this, they are now kind of completely eliminating from coverage the businesses that we think that this legislation is intended to cover. So the bill now exempts businesses that collect personal information in connection with providing a cellular service. So that's Verizon, your phone company, information in connection with providing electric, water, other utilities, internet service providers. Again, that's companies like Verizon and Comcast, cable TV, streaming services that collect a lot of information about us, like Netflix and Hulu. And then I think probably most notably of all for us is the social media companies would now be exempt. And as we know, those are the companies that collect the most.
Can I?
Wait, wait.
Well, I'm sorry.
Let him.
Yeah, I'm sorry. Go ahead.
So assuming that you're firm with wanting opt-in protections for those types of businesses, which is now contemplated in HB 314, I don't necessarily see the logic of continuing to move SB 255, or, to put it another way, excluding from 314 the protections in 255 that are very detailed and would create a lot of protections for consumers. So, that includes stuff like providing a right to access, correct, and delete. Those are kind of the baseline consumer rights that are in 255 and wouldn't be in 314. And there's other aspects of 255 that aren't reflected in 314 as well, doing risk assessments for high risk processing of data, having an appeals process if your opt-in is rejected or you feel like the company isn't honoring your request. And so now we kind of have 314 without that stuff, and we have 255, and it's kind of unclear who 255 would apply to now. I think there's likely a pretty small universe of companies that aren't covered by those exemptions, but nevertheless would be collecting that amount of information. And now you're putting on those companies, which are like companies that are likely to still be in 255, are probably going to be medium-sized businesses. They kind of now have all of these owners' requirements that I think a lot of people, when they were drafting this bill, were thinking would apply to the biggest companies. And so I think there might be a little bit of a mismatch there. And then in 314, the whole concept of the opt-in hinges on whether the business discloses information to another person. Just from a drafting perspective, I didn't see that disclose was a defined term. And so that, if you want to continue with 314, might be something to look at, because that's going to be a heavily debated area. What does disclose mean? Does that mean to sell? Does that mean to share? That's a term that would typically be defined. And same thing with the recipient. A person isn't defined term in the bill either. Another thing on 314, I would just say that I think it might be a little confusing for just the average Joe reading this. The framework of that bill says that the social media companies and all the companies that we exempted from 255 are third-party collectors. That doesn't necessarily jive with the fact that those are companies that are directly collecting information from consumers. So I think that just might be another kind of confusing drafting aspect of the bill. Yeah, I have a lot of jumbled thoughts, but I'll probably stop there. And I guess I'm just kind of left with the impression that more work would be needed to make either of these workable.
That you left
Thank
with
you.
the impression that what?
That I think more work would be necessary to make either of these workable now that we've kind of exempted a large segment from one and added it to another.
Well, thank you very much for your comments. I understand that you haven't had time to look at this proposal and ponder how to make it better, and I'm very sympathetic to that. And I also understand that you have a very important focus in terms of the consumer, and respect that very much. I do have a question that I'd like to ask you. You know, we in New Hampshire think about what happens when you build a wall, what you're walling in and what you're walling out. And what we tried to do in this draft, and perhaps we completely failed, always willing to recognize that, is to figure out who we were walling in and who we were walling out. We did not want to have companies in the private sector be confused about what they were supposed to do. We were trying to make it as simple as possible. We recognized the differences amongst the private entities who would have reason to have access to information, and hope that we divided them in a way that made sense. I'm just sitting here thinking of my wonderful father-in-law who said he didn't make the capitalist system, but he does try to live by the rules. And the irony, of course, is it's very hard to do that. I do want to point out to you, and this follows up on something that Representative Andrus said earlier, this small group will go to our full committee. We will then go to the full House. And if in the fullness of time the bill passes, the bill would then go to the Senate and open again to improvements, fine tuning that might give you some time, Mr. Schwartz, to figure out the wording that you think would be best. And that's because we do operate a pretty open system here. Longer speech than I planned to give, but I did want to thank you for being very honest and saying you haven't had time to really go through it, but these are questions that you have and you're not sure about the answers, and I respect that very much. Does anyone have any questions or comments for Mr. Schwartz? Yes, Representative Lynn.
Yeah, no, I share what the chair has said, and I understand that we're kind of catching you without having had a real chance to sort of look at this carefully, and you may have further comments or thoughts as this goes on. The one thing I guess I would say is, the concerns that you express about things that companies that would now be excluded from 255, the things that a company that is subject to 255 needs to do, and you are concerned that we've now taken a number of those companies out of it. I mean, that's all true, but I guess the thing that I think provides the answer to your concerns is what we've said in 314 is those companies can't disclose. They're, in other words, all of the things that you want protection for in 255, I think 314 essentially says no. There's no, if you've got private information, fine, but you can't do anything with it, so to speak, unless there's been an affirmative consent.
Right. Yeah. So in terms of the opt-in versus opt-out, I think that's true. And plenty of people would make the argument that opt-in is stronger than an opt-out. I guess what my point also is, though, is that 255 does a lot more than just determine the opt-in versus opt-out question. Like I said, it gives all of these other baseline rights, the right to access, correct, delete your information. And now we're carving all of those companies out from having to provide even those baseline rights. So I think that is a starter problem. Another problem is that, bills like 255, we have issues with them, but they also have thought about these issues very thoroughly. And so, in 314?
314.
Yeah, in 314, yes, you make an opt-in for consent, but then there's nothing about what a receiving entity is restricted from doing if the consumer is opted in. So like a bill like 255 addresses that by saying that a controller has to make, contractual agreements with their third parties and processors that prevents those entities from doing certain things when they've received information. And that type of kind of downstream data transfer ecosystem is not kind of contemplated in 314 at all. It kind of just says like, yeah, you can opt in to consent, and then it doesn't put any restrictions on what a recipient of that information would do. So that's just me pointing out that there's kind of a larger kind of legal landscape that has been left out once you take those entities out of a bill like 255.
Yes, no. You raised those are very good points that you just raised. Let me just ask you this. This would be a subject for the committee, obviously, to have a further discussion. But one of the big things that we were concerned about is in drafting the two bills and the two amendments the way we did is to not have a company that be subject to both, because that could create confusion. But as I hear what you're saying, would it correct your problem if we said in 255, if instead of removing from 255 all the companies that are covered by 314, we left them in 255, but simply said, for example, nothing in 255 is intended to exempt any companies covered by 314 from complying with 314.
Yeah. I think that makes a lot of sense.
So then they have to comply with both.
With both, but they're dealing with separate issues. I mean, one's about what you do with the consumer's data, and the other one's about if you can give information to the government. So I always kind of viewed these bills as having separate aims, and so to take one tranche of companies out of one and put it in the other, I think then you're not neglecting the other issue.
Okay.
So I think they can comply with both, I think.
So that would be the only wording that would change in 255 is to have it comply with 314? Is that what you were saying?
Yeah, I mean, basically, it would. In other words, I think what it would do is take the. Let me find the language that I'm talking about. Page 5.
Page 5, 5 at the top.
Yeah.
G.
So we'd have to reword that. Well, you know what? You might have to. In what I have in mind, because of the language I have in mind, you might have to. It might not fit in G, but in other words, it would be language that would say something like, nothing in this chapter shall prevent, nothing in this chapter shall excuse a company subject to 314 from complying with 314, from complying with 314, and it might also have some language saying that, something like, if companies that are subject to 314 are required to comply with whichever chapter, either the one covered by 255 or the one covered by 314, which affords the greater privacy protection to individuals. So I think that, I'd have to think about the language a little bit, but essentially it would say that companies can be subject to both 255 and 314, but if they're within the orbit of 314, then they have to comply with its greater restrictions. Some companies won't be within the orbit of 314, and so they'd only be subject to 255, but some would be subject to both.
And of course, you understand, we won't be using 314 or 255, but we would be using, because those bills would cease to exist, what we would be using are the actual RSA.
RSA, right.
Yeah, and I think I'm happy to look through it, but I think there might actually already be language in 255 that kind of reserves a business's ability to respond to a legal request or something. So there might already be something in there that accomplishes the purpose, but I'd need to look.
Thank you. Anything else? Yes, Representative Turner.
Just adding on, I think that was a great discussion around how these two interact in ways. I'm wondering also, since the 255 has the sort of universal opt-in or opt-out sort of concept built into it, whether we should also consider how that would interact with the opt-in provision of the other bill. So that if you universally opted, say, in, across the board, would you still be afforded the right to be notified and opt out? It's just a thought that builds if we go down that route. But I like the ability to universally opt out to be applied, because it takes the burden off people to constantly, make decisions one by one, if they know where they stand.
Thank you. Any other comments? Any other comments from the audience? Yes? You have to get the red light on. There you go. Thank
Great. Thank you. My name is David Miller. I'm a resident of Stratford County, and today I'd like to speak both as a resident, but also on behalf of an organization called Restore the Fourth. It's a nonprofit advocacy organization for restoring the strength of the Fourth Amendment in terms of protecting private citizens' data from government intrusion. And now that 314 is in scope here, I think Matt was presenting, Mr. Schwartz was presenting on the rights of consumers from the private sector. And I do want to thank the committee for strengthening what I think Federal Senator Ron Wyden has been trying to do for a while, is preventing the flow of information from the private sector to the federal government. Restore the
you.
Fourth is...
I don't
yeah,
want to be picky,
absolutely.
but are you here as a lobbyist?
Would that, sorry, if that would classify me as a lobbyist, I will leave out that angle and just present on my own behalf.
I think that unless you are registered as a lobbyist,
Oh, I see.
you might want to speak for yourself, and you can certainly acknowledge that there are groups out there that are concerned with this issue.
Oh, okay.
But
Yeah.
just, because these records are kept, you don't want to misstate who you're representing here officially.
Sure. Yeah. Okay.
Okay.
I'm sorry for my
No,
lack
no,
of familiarity with
I
the law.
just want to keep
Sure.
you out of trouble.
I've not a member, but I have corresponded with them about their thoughts on some of these bills, and
Good.
let me represent myself then. I'm a
Thank
resident
you.
of the state. Thank you so much for informing me. All right, so representing myself as a resident of Stratford County, I have, of course, had limited time, like everyone here, to review these bills, and I thank very much the subcommittee for acknowledging that might make things a bit difficult for us. But I just want to provide a little bit of context for why it would be so important to ensure that the rights, not just of opt out, but of amendment, correction of inaccurate records, deletion, and not just opt out from transfer, but also deletion, and the other enumerated rights in 255 are so important to apply to all companies. I understand that the wording that Representative Lynn has suggested could end up being a little bit more complicated because adding a single section not fully exempting those other entities that have opt-in requirements might sort of conflict with the wording in 255 regarding opt-out requirements. So just to sort of provide additional motivation for why it's so important to add this additional wording. And I agree that Representative Lynn's suggested wording is excellent and would probably address most of the concerns here. Data protection law in Europe, at least, dates back from about 1970 in the German state of Hesse, in 77 nationally in Germany. It doesn't seem to have affected their economy adversely. And already in the 90s was passed on the European level. And the main intent there was to prevent, ultimately, government and private sector abuses of personal data by regulating the entire downstream data flow. To describe this more fully, of course, we cannot regulate who we transfer data to out of state because of the Dormant Commerce Clause, and we cannot regulate what foreign jurisdictions New Hampshire operating company transfers data to, because that's exclusively under federal authority. And typically, the downstream transfer of data in Europe is regulated by having a list of jurisdictions where the data protection laws are considered adequate to similarly protect the information. So if you have a contractual clause that says you need to have strong protections, if it's in a country where the legal system wouldn't actually enforce that contract, obviously it doesn't protect European residents' data. In New Hampshire, we can't do all that. And so it becomes important to have a consistent mechanism of restrictions on the downstream transfer of data. So if you have different regulations, as would be proposed in the current written text presented to us this morning, for certain sets of companies versus others, you draw a graph, basically, some arrows between the different companies and what data is transferred, and there end up being holes where certain categories of data can be transferred under certain conditions, and it becomes possible to use the loopholes that result to end up with data reassembled out of jurisdiction in a way that is adversely actionable by companies or government against citizens. So in order to make those data flows regulatable by the state of New Hampshire, it is necessary to cover as many of those entities as possible with that basic list of rights. First of all, the obligation that contractual commitments have to be made for downstream flows, which is covered by 255 and not by 314, and also that at every stage of those flows, New Hampshire consumers, which it's a lot more companies covered now with a 35,000 threshold, so I thank the committee for adding that as well. You have to make sure that all those companies also allow an individual to correct their data if it's incorrect or to delete it, and all the other so-called data subject access request rights. So I would support 255 if this if the suggested amendment were introduced. One more thing, quickly. On a technical level, And on privacy level, I'm very concerned about one of the three insertions of mention of the Secretary of State. I absolutely agree that the Secretary of State should set guidelines on the procedures and user flows. However, I am concerned that as the Secretary of State defining a single type of mechanism to technically constrained for all the different companies to allow the opt-out. And the reason for that is this. In European legislation, a company is not allowed to ask for additional proof of, for example, an identity document or the identity of the individual, or let's say their New Hampshire driver's license, in order to show that they are the person who is making the request. Whatever is the normal mechanism for logging into to authenticate to the service, it has to be adequate, because otherwise you're passing a privacy bill that encourages additional collection of information by those people who care the most about their privacy. And clearly that will discourage them from pursuing their rights. So that restriction is not present in either of these bills. And asking the Secretary of State to specify a user flow, technically, that every company has to follow, means that it would be the same procedure for a company that already knows that knows the user by their email, or another company that got the data from a third party and has to verify that the individual has a certain ID, and that would not be appropriate. Thank you.
Thank you very much. And it's clear that you're quite knowledgeable about what's happening all over the world in this area. Thank you. Any questions from Ms. Miller? Not, thank you again for being here. Okay, anything else? Okay, so now we have the Senate bill, and what differs for our subcommittee action now is that in the House bill, we had this version that we could vote on. Right now, there seems to be a suggestion, I think there is a suggestion, of ways that we could improve the bill. And on my right, sitting here, I see the former Supreme Court Justice working hard on his opinion to give us language. I don't want to rush you. Do you think you have language now that you would be comfortable asking us to include in our proposed amendment, or do you need more time?
You know what, I think, let me, this is a really rough draft, and so I think I probably would not be appropriate for us to vote on this language, because there might be, as I think about it more, I might have some other changes. But I think what I think would make sense, and I ask anybody in the audience if they have a different view to if they think there's something missing from this, but suppose the language in 255 said something like this: companies that are covered by 255 and also by 314 shall comply with both statutes, with the exception that, to the extent there is a conflict between these two statutes, companies that are subject to 314 must comply with the statute that provides the greater privacy protection. So that I think would say, for example, that would say that companies that are subject to 314, which is the opt-in, they have to comply with the 250, all the 255 things about correcting your information, getting your information, having your information deleted. They have to do all that. But they also, whereas 255 has an opt-out provision, whereas 314 it's opt-in, if you're one of the companies, one of the more limited companies that's subject to 314, you have to comply with it's greater privacy protection, which would be the opt-in as opposed to the opt-out. I think that would would do it. And I'm just wondering if
This is my, if it's
yes,
okay.
of course, no, no, of course.
This is my suggestion. We can't in the amendment, it makes no sense in the amendment for us to use 255 and 314. What the amendment would have to do, would have to be drafted in such a way as to refer to the RSA sections, because the independent existence of the two bills disappears. And so that requires, some careful review to make sure that we have the right sections in there. So this is my proposal, and you don't have to agree, of course. My proposal would be that we ask Chairman Lynn to come up with the language that is appropriate to be added to Senate Bill 255. He's free to share it with all of us, but we can't discuss it in private. So, that's all. What that would mean then is, for the purposes of today, and I, of course, would be very happy to help you do that. We leave today's discussion of 255 saying that we are comfortable with the draft amendment with certain additions. And that would just be our report for this meeting. And that we come together at 9:30, which is always very good for Representative Devine. She likes nothing more than 9:30 in the morning. Well, I mean, to be here. And that, or even at 9:45 on the morning of the 8th. And we, having seen the language before, would be ready as a subcommittee to vote on it. And assuming that we can accept that language, then we would be free on the 8th to present to the full committee the amendment that we agree on. Other than that, we would have to have another meeting. And while I love your company, and I'm sure you love mine, I don't think any of us need extra meetings. Does that meet our requirements? So we can work on that language. We would then get it to OLS. What we would have then to vote on 9:45, even on the 8th, would be the final language. You will have seen it before, but we would not have discussed it. And then the full committee in its work session could review that. Does that meet everyone? Representative, I can't see you. Is that okay with you? Okay. That being the case, we are ready to send to OLS 314 as amended in the way that we've agreed to get a final amendment. And then we will work on this change, which we would then send to OLS for them to have a final amendment. And those amendments would be in the subcommittee's name, or however OLS will. You never could tell what they'll say, but I mean, who knows? Whichever name is appropriate. And we would then come together on the 8th as a subcommittee for a few minutes to approve the final language, and then be able to go to the full committee to present it. Does that cross all the Ts and dot all the Is? Everybody okay with that? Okay. Mr. Miller, you have something you want to add? Could you please come here because there are people who are watching this with bated breath.
Thank you. And I think some of my prior points I also may not have made clear, but I'm relatively happy with the outcome. The reason that I was mentioning the history in Europe was not just for trivia, but because of the importance of each node in the graph of a data flow having an flow chart, so to speak, having these similar protections. And we do have a mix under the proposal of opt-ins and opt-outs, and that is almost fine because opt-ins are generally considered to be stronger than opt-outs. But there is one thing missing in the way opt-in is defined in 314 compared to other similar legislation. So in ADPPA, the federal bipartisan bill that didn't get past Pelosi.
Excuse me?
Oh, there's a federal bill called the American Data Protection Privacy Act.
Okay, and that has not yet been passed. Is that
Correct. There was a
Fine,
lot of
thank you.
bipartisan support, but
Good.
it didn't get past the chairwoman. Okay, so in that bill, similar to what you're trying to do here, with this combination of the two portions of the RSA statute, there are a certain set of stronger requirements that apply to these large social media companies, etc. And there's a different set of requirements for the smaller ones. But there's also a data minimization requirement. And what that means is it is a mechanism to prevent what's called consent fatigue. Consent fatigue is when every few minutes you get a pop-up that says, hey, you want to let us do this thing with your data? And then when you don't click it, a few minutes later, you get another one. And ultimately, it's very hard to enforce your rights if you think you can't use a service unless every few minutes you're willing to swat something away that's bothering you, right? So data minimization is a fairly basic part of data protection law for the last 50 years. And this is the requirement that it is actually a data controller's burden to make sure that they're not asking for more than they need to provide the service. And that is missing here from both 314 and 255. And by leaving that out, we create a government, the government creates an incentive in the private sector for companies to try to use consent fatigue to obtain consent for excessive collection, processing, and transfer of information. And that is a concern that I have with the current proposed setup.
Thank you. Could you tell me in the states that have taken action to try to fill the void by lack of action at the federal level, is that data minimization in each of the state laws?
Data minimization has been successfully lobbied out of the majority.
Actually, that's
Of
not
the
what I
current
asked. I
past
asked,
ones, yeah.
is it in the state law
It is in California,
in
yes.
California?
And the subsequent bills have been crafted to not include it. It is under consideration in the Massachusetts and Maine legislatures at present, which has a potential to influence regional compliance.
Great. Thank you. That is very helpful information. Appreciate that. Anybody have, yes, Representative Tur.
Yeah, just one question on that point, and I think goes back to the point I was interested in earlier. With the concept in 255 of universal opt-in or universal opt-out, does that mitigate the consent fatigue question without the concept of minimization?
Not unless there's a clear legislative imperative to a clear imperative in the legislation that companies cannot employ consent fatigue to attempt to gain consent. And it's not clear to me that are you referring to particular wording that you think provides that requirement?
My understanding in 255 was that the way it's worded, it would allow there to be technology used that would allow you to sort of universally opt in or universally opt out, whatever be your preference for data sharing in general. And so I didn't know whether essentially it would be something you would set, say, in a browser, my understanding, that would be then applied across the board, and hope I'm understanding that correctly. So, because I agree with the concept of consent fatigue being, a difficulty both for privacy and for just the logistics of people's lives.
That's an excellent point. So, with regard to that particular portion of 255, my concern here is that that doesn't apply to the protection in 314. If wording were to be added in 255, that would ensure that those requirements applied also to the opt-in provision of 314. That might, depending on the wording, address this concern. But one additional thing that I'd like to mention is, I think, on all sides of this issue, everyone agrees that legislation and technology the legislative process and technology move at different paces, right? And sure, when we talk about browsers, there is a thing called do not track that resulted from years of negotiations by people setting web standards in a lot of different countries. Mozilla Foundation was a big actor, but it was their own kind of private sector standards legislative process. And the fact is that people access the internet from a lot of different services. There's no such flag on all mobile OSs. There's no such flag on Internet of Things. There's no such flag on your refrigerator that people can hack to get your email. So we have no idea what signals will be available to be sent from various devices and programs a year from now. So relying on that may not work.
Thank you. Thank you very much. Anything else? If not, then we'll end this subcommittee meeting. We will meet again at, and it will be posted at 9:45 on the morning of November 8th, at which time we will vote on our proposed amendment on Senate Bill 255. And does that complete our business? Does anybody have anything else that they'd like? No, then we are finished. We're adjourned. Thank you.
Thank you.